Another issue that you'll have, and I'm not sure of how to address it, but I just want to bring it before you, is the fact is many churches do discriminate based on sex. We're talking about a pastoral leadership role or many of the leadership roles that are within a church. If the city leaves the language as it is, those churches could have a lawsuit filed against them. Frankly, I'm not sure of the solution on that. I think this language in here is fairly typical across the country. You may want to include an example that provides what you're talking about. I don't know how to solve it. I just want to raise it for your attention. Going to page 15. The two issues here, the section of the ordinance that's protecting religious organizations at the top of the page. First of all, a similar issue to what we just addressed in the last one, except to the reverse. It says that a religious organization is protected and is allowed to discriminate unless it discriminates based on religion and its membership. Once again, that means no churches have this protection. No religious organizations of any type have this protection if they require you to be a member of their religion to be a member of their religion. You understand? So it's a very simple fix, but we just need to take out religion. Otherwise, this doesn't protect anyone. Similarly, and this is a slightly different issue, and if you look at, for instance, the state statute, section 44-1018, that exemption does not include religion in this language for precisely that reason. When it limits it to persons, being able to rent to persons of the same religion, you're going to have a significant problem here, too, because a lot of churches, a lot of religious organizations, like that camp I told you about earlier in New Jersey, rent to non-religious organizations for uses of their property which are consonant with their religious beliefs. For instance, a church will rent out its sanctuary to for a marriage. It may not be that the marriage is between two Baptists, but it's still a marriage, and there's nothing wrong with a marriage in the eyes of the church. But if that rental to non-Baptists is sufficient to rid them of this protection, now they're not going to be able to, when they're talking about issues that are morally important to them, like sexual orientation or gender identity, they won't be able to make that same decision. There's a distinction here, a significant distinction. In the first case, we were talking about something that is morally within the bounds of the church's teaching. In the second instance, you're talking about something which is outside those bounds. And so the language needs to be reworked here in a way that allows churches to make those kinds of decisions without losing their religious liberty protections. Going back to page 11. Number 7, at the very top of the page, subsection 7. There's a couple issues here, primarily with just the language that can be fixed. One, there's no religious liberty exemption for this. And this is very broad, as Mr. Hampton brought up earlier. And because it's so broad, it doesn't, for instance, it doesn't restrict itself just to this chapter. It's not just talking about employment discrimination necessarily. On the plain language, it says, any acts forbidden under this chapter. Well, the chapter includes the entire section, the entire ordinance. Other portions was when it say under this section, when they mean just the subsection with employment discrimination, public accommodation discrimination, housing discrimination. So this covers everything. And it says if you do anything which encourages people to aid, abet, incite, compel, or coerce doing anything that's forbidden, you violated the law. And because there's no religious liberty exception here, potentially giving a liberal construction when a pastor preaches on, for instance, homosexual behavior and says this type of behavior isn't good, that's aiding, abetting, or inciting people to take a position that would be contrary to the position that's now been affirmed by the city, that type of behavior is good. So you have not only significant free exercise issues, but a significant free speech problem if the language isn't reworded to add a religious liberty exemption. The next section down, when this was addressed, so I'll just be very quick about it, it does create a form of reverse discrimination, and it is, like Larry said, in the state statute. But, and the state statute's been around for a very long time, but just last year, the Supreme Court said, if you're going to stop, if the goal is to stop discrimination based on things like race, then we need to stop discriminating based on race, when it was deciding a case about white firefighters in New Jersey. So the Supreme Court is signaling a sea change in its, on affirmative action type provisions that are similar to this one. They say you can't discriminate based on sex to benefit other people based on sex. You can't discriminate based on race to benefit people based on race. I'm not saying that's where the law is right now in Kansas, but that's where the Supreme Court signal was going just last year, and it's something to be aware of, again, because of the litigation concerns that will be caused by a liberal construction of the statute or the ordinance. If we go down to just on the same page, just below that number, subsection 1, when it's talking about the different places, facilities, and things that you're not allowed to discriminate based on, this type of provision goes exactly to what I was talking about earlier. The Elaine photography case in New Mexico, the Just Cookies case out of Indianapolis, the Gospel Mission that I was referring to. All those types of organizations would be bound by this kind of provision if that language that we looked at earlier isn't fixed. And we're not just talking about things like that. We're talking about Manhattan Christian College. We're talking about hospitals in the area. We're talking about bathrooms and locker rooms. All sorts of situations where if the language isn't fixed, you're going to have a significant issue. And frankly, even if you fix the language, you're going to have a significant issue because, as we addressed earlier, sexual orientation, gender identity just opens up a whole new situation, a whole new can of worms, so to speak. Page 16. We're getting close to the end, I assure you. Page 16, where we go to the section where it says under 10-19 subsection A, when it says they are about to be discriminated against. This is a significant concern. I believe one that was raised by the county attorney recently because it's hard to determine. When we already got broad terms, now we're turning them into something that's about to happen. It's going to be very hard to enforce. And in fact, the state statute doesn't allow that. The state statute, section 44-1005, doesn't include that. It does allow claims for people who have been discriminated against, but not people who allegedly are about to be discriminated against. The last point that I want to make is that the administration of this ordinance is likely going to be quite expensive. Lawrence, it costs them $150,000 per year just to have an attorney and staff in place to handle it. And after, I believe, the first year they did it, they ended up having to rescind that department and push it into the legal department and just add all those responsibilities into already probably overworked staff. And in Sioux City, Iowa, a similar city not too far away, they had to pay $250,000 a year, again, just for the staff. This is not talking about costs that are associated with enforcing the statute, with enforcing cases. It's certainly not talking about the costs that are associated with small businesses or churches or charities or anything else defending the ordinance, defending from the application against them. It's just talking about what it costs the city. When you add all these other things in, you look at, for instance, on page 23, where an employer can be deeply penalized by having to pay back pay and retroactive benefits and things of that nature. It could be very significant, very costly, and that's if they lose. Even if they win, it could be very costly. For instance, in the Gospel Mission case that I told you about earlier, 1 year, remember the big flow chart that you had up in front of you earlier? It's nicely put together. It was very instructive to me. The investigation phase was right at the beginning. We have never left the investigation phase in that case. Tens of thousands of dollars, nonetheless, in legal fees, if they weren't free, and hours that attorneys put in defending it, just in the investigation phase. This organization was ordered by the Human Rights Commission to provide documents of their financial status, of their donors, their employment, their operational, their theological, all these different types of documents, and to make their employees available for depositions, for discussions and investigation and things of that nature. Significant just in the investigation phase. And you saw how much further down the flow chart went. So even if the business is in the right, in all these circumstances that we've talked about earlier where increased litigation will occur, even if they're in the right, they may never find out about it because they may not exist to afford it. They may be out of business before they ever get to the chance to bring that up. So these are the issues. We talked about the general problems, the specific problems, many of which are fairly quick to fix, but some of which are intractable, like the religious liberty issue. Here are the recommendations I have for solutions. One, make those changes that I talked about. if that's in the council's, of course, in the board's decision. But a lot of them will fix some of those problems. Before that, though, consider not enacting the ordinance at all. There already exists a mechanism to protect almost every one of these situations. The only ones we're talking about that will cost the city all this money and cost all the time and change the whole function of this board are the sexual orientation and gender identity protections. That's it. Everything else is already protected and already paid for by the state. So I would encourage you not to enact a law which by its very nature will cause conflict with the religious liberties of the people of Manhattan. And if that is not the decision, and I understand to a certain extent that's not this board's decision to make, it's this city council's decision. But if it's not something that can be done, at the very least, the absolute least, have a broad religious liberty provision that protects not only the rights of churches to protect their consciences, but also of individuals, because that's what's protected under the Kansas Constitution. The right of their consciences not to be violated, them be forced to do things that violates what they believe to be right and good.